Sahaj Vidhi www.sahajvidhi.in Question 1. Who are minorities? The Constitution of India protects the rights and interests of minorities to the extent that the rights conferred to them to establish and administer educational institutions of their choice are not absolute and are subject to reasonable restrictions. Discuss with the help of decided case laws. Model answer. The concept of minorities in India is crucial for understanding the constitutional safeguards provided to specific groups. While the Constitution does not explicitly define a minority, it implicitly refers to religious and linguistic minorities, particularly in Articles 29 and 30. The Supreme Court has, through various judgments, clarified the scope and application of these rights, emphasizing that while significant, they are not absolute and are subject to reasonable restrictions. Who are minorities? For the purpose of constitutional rights, particularly under Article 30, minorities are generally understood to be groups based on religion or language. The determination of minority status has been a subject of judicial interpretation. T.Ma. Pi Foundation v. State of Karnataka, 2002. This landmark judgment clarified that for the purpose of Article 30, a religious or linguistic minority has to be determined by reference to the population of the state and not the whole of India. This means a community that is a majority nationally could be a minority in a particular state, and vice versa. P.A. Inamdar vs. State of Maharashtra, 2005, reaffirmed the T.Ma. Pi Foundation ruling regarding the state-wise determination of minority status. Bal Patel v. Union of India, 2005. The Supreme Court observed that the term a minority should be understood in its constitutional sense, primarily referring to religious and linguistic minorities, and cautioned against extending it to other groups without proper constitutional amendment. Constitutional protection. Article 30 of the Constitution specifically protects the rights of minorities. Article 30, 1-2 All minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. Article 30, 1A ensures that the amount fixed by the state for compulsory acquisition of property of a minority educational institution would not abrogate or abridge the right guaranteed under Clause 1. Article 30, 2 prohibits the state from discriminating against any educational institution in granting aid on the ground that it is under the management of a minority. Rights are not absolute, subject to reasonable restrictions. The right to establish and administer educational institutions of their choice, while fundamental, does not imply a right to maladminister. The Supreme Court has consistently held that these rights are not absolute and can be subjected to reasonable regulations aimed at ensuring academic excellence, proper administration, and the welfare of students and teachers. Judgments illustrating this include 1. Kerala Education Bill, in Re. 1958. This was one of the earliest cases where the Supreme Court held that while the state cannot destroy the minority character of an institution, it can impose reasonable regulations to ensure educational standards, hygiene, and proper conditions for teachers and students. Regulations that are regulatory in character and conducive to the welfare of the students and teachers are permissible. 2. St. Stephen's College via University of Delhi, 1992. The court held that minority educational institutions have the right to admit students of their own community, but this right is not absolute. Can reserve up to 50% of seats for their community members, but the remaining seats must be filled on merit, and the admission process must be fair and transparent. The state can regulate the admission process to ensure merit and prevent maladministration. 3. T.Ma. Pi Foundation v. State of Karnataka, 2002. This landmark judgment extensively dealt with the scope of Article 30. It reiterated that the right to administer does not include the right to maladminister. The state can prescribe qualifications for teachers, conditions of service, curriculum, and other academic standards to ensure excellence. However, these regulations must be for the welfare of the institution and its students, and not such as to destroy the minority character or autonomy of the institution. The court distinguished between aided and unaided minority institutions, allowing greater autonomy to the latter in matters of admission and fees, subject to preventing commercialization. For P.A. Inamdar v. State of Maharashtra, 2005. This judgment further clarified the T.Ma. Pi ruling. It held that the state cannot impose a quota system or a common admission test, like CET, on unaided minority professional institutions. However, the state can regulate fees to prevent profiteering and capitation fees, and ensure a transparent and merit-based admission process. The court emphasized that the state's regulatory power is to ensure that the minority institutions maintain academic standards and do not indulge in commercialization. In summary, while the Indian Constitution provides robust protection for religious and linguistic minorities to establish and administer educational institutions of their choice, this right is not unfettered. The Supreme Court, through a series of judgments, has carved out a balance, allowing the state to impose reasonable regulations to ensure educational standards, prevent maladministration, and promote the welfare of students, without undermining the minority character or autonomy of these institutions. This approach reflects the constitutional commitment to both minority rights and the broader public interest in quality education. Please visit our website www.sahajvidhi.in for more content.